Justin Muturi on the resignation of MCAs on the 8th of February 2022, and also to be able to clarify the confusion therein on the issue of resignations. And fellow Kenyans and members of the fourth estate, on the 8th of February 2022, the Honorable Speaker of National Assembly, Justin Muturi, was recorded making a statement that a sitting member of County Assembly must resign 6 months to the election date if he or she wishes to vie for the seat of Member of Parliament. This statement is a huge disappointment to the County Assembly's forum and the whole nation at large, considering that not only is it not true, but lacks a forethought to the current judicial precedents set by the courts. CAF hereby declares that this statement issued by Honorable Speaker was unfortunate, distressing, and misinformed and unnecessary. That as the Speaker of the National Assembly, he cannot be seen to be contradicting the courts on matters of interpreting the Constitution of Kenya or the statutes, especially when the courts have complete jurisdiction in all matters of interpreting the laws of the country. That Article 99(2) of the Constitution of Kenya has already been interpreted by the courts, and jurisprudence has been set under petition number E369 of 2020 and constitutional petition number 321 of 2017, that the courts have delivered themselves on the above matter and created a resounding and elaborate jurisprudence thereof. In Kennedy Irungu Ngodi and another versus Mary Waithera Njoroge and 11 others, petition number E369 of 2020, the learned trial judge stated that Article 99(2) subarticle D did not disqualify a sitting MCA from contesting for Member of Parliament. However, in case a vacancy occurred in the National Assembly and there is a by-election, then the Member of County Assembly must first resign in order to contest for the seat. Further to this, in his determination, he stated that a sitting president, governor, Member of Parliament, or MCA who intends to vie for any seat in a general election, next, upon the expiry of the current election cycle, need not resign before the general election. The Honorable Judge, Justice Mrima, held that all the respondents, members of Parliament, former MCAs, who are the former MCAs, those who are respondents in that matter, were former MCAs who are currently serving in the National Assembly, were eligible to vie and be elected. These findings were informed by the provisions of Article 38 and 41 of the Constitution of Kenya and Section 43(6) of the Elections Act 2011. According to the learned judge, Article 99 subarticle 2D only prevent concurrent occupying of the seat of Member of Parliament and of an MCA. Constitutional petition number 321 of 2017, Justice Mativo held that it is clear that the law does not prohibit a member of a county assembly from being nominated to contest for a parliamentary seat in a general election. It is also clear that the term of office ends on the date of the general election as per Article 177 subarticle 4 of the Constitution. However, if the election in question is a by-election, which would ordinarily take place before the term of the county assembly expires, then such a member would obviously be required to resign. Further to this, he retaliates that a declaration, I quote, that a declaration be and is hereby issued that the term of Member of County Assembly, including county assembly speakers, expires on the date of the next general election. That a declaration be and is hereby issued that a member of a county assembly is not disqualified from being nominated to contest in a general election as a Member of Parliament by virtue of Article 992D and the Constitution. End of quote. Yesterday, again, the Court of Appeal in Civil Appeal number 119 of 2017, that is Public Service Commission and others, and Eric Cheriot and 18 others, the judges of a Court of Appeal, Honorable D.K. Musinga and W. Karanja and A.K. Murgo, upheld the appeal by the Public Service Commission requiring public officers to resign 6 months to the general election, and in the same breath held that Section 43 subarticle 6 of the Elections Act is innocent and harmless, as it is a replication of the Constitution on the subject. That the only decision, quote, Clement Kungu Waibara versus Anne Wanjiku Kibe and another, that's petition 210 of 2020, that required an MCA to resign has since been suspended, or stay of execution orders were issued by the Court of Appeal following the full determination of the matter. In light of the foregoing, MCAs across the country should remain calm, campaign for the elective seats they decide to occupy during the August elections, as they continue to diligently serve the people as members of county assemblies. We know very well, as we speak, that we have former members of county assembly who are sitting both in the National Assembly and the Senate, whereas they did not resign before they contested for the current positions they hold. The law cannot be interpreted retrogressively. So we seek that they desist, such officers should desist from that. And we want to encourage JB Muturi, having declared to be a presidential candidate, that he really needs to be cautious about the statements and sentiments that come out of his office, especially during this time where everyone needs to be very cautious in the country. And we call for harmony and calm across the county assemblies. And as the law has clearly stated, and the courts have pronounced themselves, we encourage everyone to stay and be calm and follow the law and the directions that have been given by court, I think.